Statement. I declare open this public hearing of the Parliamentary Joint Committee on Intelligence and Security for its review of item 250 of the National Anti-Corruption Commission, Consequential and Transitional Provisions Bill 2022. These are public proceedings, although the committee may agree to request to have evidence heard in camera or may determine that certain evidence should be heard in camera. The hearing today is being conducted by video conference for nearly all participants. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege unless you are giving evidence from outside of Australia. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Parliament as a contempt. In accordance with the committee's resolutions of 7 September 2022, this hearing will be broadcast on the Parliament's website, and the proof and official transcripts of proceedings will be published on the Parliament's website. I now welcome the representatives of the House of Representatives, I think the official title, the clerks, to give evidence at this public hearing today. For the Hansard record, would you each please state your full name and the capacity in which you appear before the committee?
Thanks, Chair. Peter Banson, Deputy Clerk of the House of Representatives.
And Richard Pye, Clerk of the Senate.
Thank you. The House and the Senate. Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as the proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Thank you for your attendance today. I might ask if you have an opening statement or a remark that you'd like to open up with before we get into some questions. Over to you.
Yes, Chair. Richard Pye, Clerk of the Senate. I've got an opening statement on behalf of both of us. Just to put our submission into context, the committee has before it a submission from myself and the Clerk of the House of Representatives, Clarissa Surtees. The context that we think is useful to keep in mind is that whenever you're seeking to regulate the conduct of parliamentarians, it's always important to think about how the statutory scheme that you're developing interacts with parliamentary privilege. This usually involves really two things: a consideration of whether and how parliamentary privilege applies, and what is the venue and what is the process for resolving any disputes about the application of parliamentary privilege. Usually, when we talk about privilege, we're looking to the courts and the Parliamentary Privileges Act to provide that venue and that process, but that's not usually available when you're talking about a statutory scheme which involves the executive and the Parliament. The courts don't really like to get involved between the executive and the Parliament on matters of the scope of privilege, the application and interpretation of privilege. So they like to leave it for the executive and the Parliament to sort that out. The experience of various states that have corruption or anti-corruption commissions is that a combination of legislation that preserves privilege and a protocol that provides the ground rules for determining how privilege applies and what how claims of privilege may be made and determined. That's the right balance. We've seen in the last year or so a case in the WA Supreme Court that, among other things, gently encouraged the Parliament and the Executive to get together to develop a protocol for how matters of privilege as between the Commission and the Parliament should be determined. This week, the New South Wales Legislative Council Privileges Committee put down a report on the execution of search warrants in relation to a member of the council, which reminded people of the existence of a 2014 draft protocol about how privilege should apply between the Parliament and ICAC, and the committee this week has recommended that that process be revived so that an up-to-date protocol can be developed. We know that the legislation for the proposed National Anti-Corruption Commission preserves privilege through its provisions, but the TIA, which is the subject of your inquiry, the TIA is silent as to the application of privilege. We would argue, and it certainly is the position of the houses, that privilege applies in the exercise of powers under the TIA, but the difference in treatment between the NACC bill and the TIA Act might leave people to conclude incorrectly that privilege doesn't apply when the NAC is using powers under the TIA. So that really is the context for the two matters really that we raised in our submission. So that first matter is whether privilege is sufficiently recognised and safeguarded in the operation of the TIA. Clerks of the Parliament have previously put these matters to the committee in the context of other statutory schemes, including the FIT scheme about 4 years ago. And the second matter that we raised is related to the idea of how protocols to enable claims of privilege to be made and determined ought to operate in this space, particularly given the secrecy provisions that exist within not just the TIA but also other legislation dealing with electronic surveillance. So that's really the context of the submission and a really high-level outline of what it contains. Thanks, Chair.
Thank you very much. I might start with a couple of questions I have. I've obviously looked at the submission that you've made. So the first argument really, if you could explain to me too, is that there is an argument being made that because there's an assumption that there's a greater likelihood that of powers under the TIA Act being used in relation to privileged parliamentary material, that in itself will, because of the volume or the increased volume, assuming that would be the case, because of that increased volume, that would somehow test the assumed protections being in place, based on Section 49, as you referred to earlier. But I guess my question is, just because something is exercised more, that doesn't necessarily diminish the position of Section 49 as providing that it's there. Just because you're doing more of these under that particular act doesn't necessarily mean that Section 49 is diminished by increased volume. Do you get where I'm going on that?
I do, Chair. I completely agree in relation to the point that you're making. And this is really the approach that we took in relation to our submission on the FIT scheme bill a few years ago. I mean, an absolute purist would say, wait a minute, the statute law of the Commonwealth, unless you have an express provision that abrogates privilege, then privilege remains in place. So a purist would just say, there's no need to do anything in this space. There's not even any need to put anything in the NAC bill to say privilege is preserved, because absent express words to the contrary, privilege is preserved, it's not abrogated. The difficulty arises as soon as you're implementing a statutory scheme that goes close to the proceedings of Parliament itself, which the FIT scheme did. The FIT scheme in particular was included.
So what do you mean by goes? What's the difference in degree there about going close? Because I would have thought the problem was what you've just described is that the NAC bill, because the NAC bill expressly preserves privilege, it's almost the argument that's been made in the submission is that because of that and the fact that the contrast is with the TIA Act, which doesn't expressly preserve privilege, therefore there might be some confusion as to the underlying protections that they're in the Commonwealth statute, in the Constitution, I should say.
Yeah, no, you're exactly right, Chair. I think it is the concern that people will be confused into thinking, hey, we can see an express preservation of privilege in this part of the exercise of the Commission's power, but not in relation to the use of telecommunication interception powers, and therefore it might give people the impression that privilege doesn't apply in that space. But you're quite right. Our view would be that it does. You get more confusion as soon as you give somebody some powers that seem to reach into all the activities of parliamentarians, including possibly their participation in parliamentary proceedings. That was the issue with the FIT scheme bill. It had provisions that were specifically about influencing the parliament, and so we took the pragmatic point of view in our submission to the committee that you want to avoid that confusion by making sure people are aware that privilege is meant to have primacy in that space. Really, it's the same argument here.
Is the argument really about an abundance of caution in some respects? Because in your statement there, you're accepting that the presumption that powers, privileges and immunities of both houses and the committees and their members per section 49 is not affected by legislation except by express words. Now, clearly there are no express words. In fact, the only thing that's happening here is that, there's no express words in the TIA Act. It's just silent on the matter. So the assumption then is it's not going to be abrogated. That's the kind of precedent, the law that's accepted. But what you're saying is because there's a positive expression preserving privilege in the NAC, somehow that is going to cause some confusion. I'm not sure who would be confused, but people looking at the TIA Act saying, oh, well, they don't say it as well. If we go down that slippery slope, every single act is going to have to expressly preserve privilege or have some section that reaffirms what Section 49 already tells us.
Yeah, I mean, you're exactly right. We're in agreement, Chair. I think the issue, though, is that, confusion among people, including the agencies occasionally that exercise some of these powers, is more likely when you've got a contrast in how one statute deals with the power and how another statute does.
So in your recommendation then to deal with that part of the confusion is to do what exactly? What would you be recommending?
Well, we suggested that there's a couple of different ways that you could include the same statutory language in relation to the exercise of the power, either by including something in the TIA itself or by putting an amendment into the NAC legislation that puts beyond doubt that the protection of privilege or the preservation of privilege that the NAC bill suggests extends to the Commission's use of its other powers, including the covert powers under the TIA.
Okay, and so I assume the other option here, which is not expressed in the submission, would be to not expressly, in the NAC bill itself, not to expressly preserve privilege or have a statement about that, and remain silent in the NAC bill as well, because that would confirms a kind of consistency, I guess.
Exactly. I mean, it would be an option, but it's not the way the government chose to proceed in the FIT scheme bill. They went, no, we better put some provisions in this bill that clear up any confusion for people because the powers that were being implemented under the FIT scheme definitely went to the proceedings of Parliament. So given that approach was already taken in that Act, the same or similar language has been used in the NACC legislation. So the extension that we thought to recommend here was that the same approach be taken in relation to this power.
Yeah. And last question, also you're obviously in the submission talked about the need for protocols as well, similar to what is in place with the FITs.
Well, it's more similar Chair, to the protocol that's in place in relation to the execution of search warrants where privilege might be involved. The suggestion is that, and the Senate has adopted a resolution that expressly says that a protocol should be devised in relation to the intersection between privilege and the exercise of covert investigative powers. The issue that we highlight in particular in the submission is that there are secrecy provisions that prevent people who are exercising these powers from providing any information on to others about it. It makes it very difficult to devise a protocol that lets people make informed claims around privilege if they can't be given the information that that they need to make that claim.
Yeah. I'm going to hand over. I saw Senator Patterson's hand going up because he's
Thank you, Chair.
on video. That's why I saw you. Over to you, Senator Patterson.
Thank you, and it's a good segue because my questions follow from that
And
last
Julie's.
statement that you made, Mr. Pye. By its very nature, these powers are covert, and that's appropriate. They need to be covert for them to work. And by its very nature, a claim of parliamentary privilege needs to be made by a parliamentarian. So if a parliamentarian is subject to a covert surveillance under this legislation, how will they have the opportunity to make a claim of privilege over any of their stored communications?
Yeah, I think that's a really good question, Senator Patterson. Very, very difficult set of circumstances involved there. The Senate Privileges Committee's looked at this in a couple of its reports in the 45th Parliament, possibly into the 46th as well. And that's why the recommendation was to set up a working group in the last Parliament to have a look at the issues involved. What it might involve is, instead of the parliamentarian who is subject to a covert search being the person who examines the privilege question, you might use President or Speaker, you might use someone else with an attachment to the Parliament. If you're establishing other commissioners to look at the Parliament, then you might use an avenue along there. The idea might be that some standards be developed in relation to the point at which an agency might have to make a decision as to whether privilege might be engaged in a matter or might not, and might in those circumstances need to take additional advice at a higher level within an organisation, which is something that now exists in the search warrant space. Really difficult questions. And one of the things that the Privileges Committee was really very keen to point out was that they didn't want to interfere with investigations. It won't be very often that questions of privilege arise in this space, but it could be something that arises in relation to, for instance, whistleblowers providing information to senators and members to bring before committees and that sort of thing, where you're in that information space in relation to other investigations that you might expect the Corruption Commission to be dealing with. They probably don't come near proceedings. But where there is this question of proceedings, trying to find a way that the question of privilege can be given some regard by someone separate from the investigative process itself, with some insight into the operation of privilege, is probably the sort of direction you'd expect it to go.
So this is my concern. As this bill sits before this committee, and as the other main bill sits before the other parliamentary committee, I think they've returned their report on it now, there are no provisions which deal with this issue. There is nothing which says there will be a third party which will be able to make a claim of parliamentary privilege on behalf of a parliamentarian who's subject to one of these warrants. It is completely undealt with, and I'll put this to the Attorney General's Department later and see what their proposals are for how this issue should be dealt with. I don't mind your proposal of potentially having the presiding officers playing a role, although there is an issue that, although we of course respect the position of presiding officers in our parliament, they are partisan political figures as well as being presiding officers, and they might have to make a claim of privilege on behalf of a parliamentarian who's not from their political party, and that puts them in a difficult position. The other alternative, which I think this committee could consider, is in other contexts, particularly the Press Freedom Inquiry, which this committee considered in a previous parliament, we recommended that a public interest advocate have a role of contesting warrants that are made against journalists, so that journalists' rights and freedoms could be protected without them being tipped off or notified that they're subject to a warrant. Now, again, this bill doesn't deal with it. The other main bill doesn't deal with it. What is your view on either the presiding officers or a public interest advocate or some other independent person being in a position to make a claim of privilege on behalf of the parliamentarian?
I think that that's certainly an option that warrants further investigation. I think that it has been the subject of discussions by the working groups involved in this space in the previous parliament. You're quite right in that you can't derail. You don't want to derail an investigation in order to deal with the possibility of a claim of privilege. It's also important to make sure that senators and members aren't making exaggerated claims of privilege as well. Privilege is a powerful and important principle, but it attaches to a very narrow part of what parliamentarians do. So having a protocol that helps senators and members also understand that there are spaces where privilege just isn't going to go, and therefore there's no need to think about how privilege operates in that space is a really important thing as well. If an investigation, if we take the example of IPEA, for instance, the expenses authority that oversees the use of entitlements by senators and members, use of business resources by senators and members, we're always pretty keen to say, well, IPEA has the power to search and seize material, including via computer systems in this place. But the entitlement space isn't somewhere where privilege would ordinarily be thought to apply, and we've had cases in the UK and here that point out that principle. So if you've got a protocol that says, well, as long as the investigation is a long way away from the proceedings of Parliament itself, there's really no need to take into account privilege. You might end up in a space where people are incidentally capturing material that is that forms part of proceedings in Parliament, and having a process by which that can be set aside by an investigation, either on the basis that it won't be central to the investigation or on the basis that some question of privilege arises and there must be a process to deal with that. But as you say, Senator, you don't want to tip off the person as the subject of the investigation to that happening. So having another process for advocating on the privilege question would be highly appropriate in that space.
Thank you. And just a final comment from me, Chair, then I'll cede to other committee members. I agree with you. It's not going to be in every instance or every investigation where this might be relevant, but I think there are scenarios where it is completely plausible. And I think the whistleblower scenario that you outlined is one of those. A parliamentarian who is subject to the NAC could be receiving material from a public servant who is also subject to the NAC, and in a series of leaks, and I might be using that material in speeches in Parliament or as part of a committee inquiry. And if the NAC was concerned about the flow of that information and launched an investigation into it, it's highly likely that communications between me and that whistleblower could be subject to parliamentary privilege, and I have to have, or someone on my behalf has to have an opportunity to make a claim over that.
Agreed, Senator. I understood that there was a process occurring to have a look at all of the electronic surveillance schemes and perhaps reform that legislation in an omnibus process through this Parliament or possibly the next, and that might perhaps be a good occasion for these questions to be further ventilated.
Yeah, I think there is. It's called the Electronic Surveillance Reform Process, which the Department of Home Affairs is conducting, although I suspect that might take some time and certainly wouldn't be ready in time for this bill to become operational.
No.
So I think something needs to happen in the meantime, in my view. Thank you, Chair.
Thanks, Senator Patterson. Mr Hill, got his virtual hand up.
Oh, hello. Is that working?
It is. It did work. Yep.
We can hear you, Mr.
Visuals
Hill.
might be frightening. Oh, well, we'll see how we go. It's very early morning in my hotel room in Perth. Hello, how are we? Look, thank you. I think most of my issues have been covered. I just wanted to clarify two things. Just picking up Senator Patterson's point regarding potential advocates on behalf of parliamentarians in relation to a claim of privilege. Is it something that the clerks would be able to exercise? Because I take Senator Patterson's point that I'm just trying to reconcile the two sort of discussions that you've had. I think you made the point, Clark, that someone close to the parliament would be advantageous or desirable. And Senator Patterson made the observation that presiding officers ultimately usually have a partisan background. Is it something that the clerks may be able to exercise on behalf of the parliament, or would that put you in a difficult position?
I think broadly speaking, it would be something that the clerks could do. The difficulty, of course, is there may well come a point at which you end up being the advisor to the investigative body, and also a senator or a member comes to you for advice on the same issue, and you've got to make sure that you have a clear separation there between those two roles. I've suggested in the past that there are a couple of very good former clerks hanging around the joint as well, and having the opportunity to go to them might be another alternative as well. But yes, in relation to the search warrant protocol, for instance, when material about which a claim of privilege has been made is sealed away, it's usually given to the clerk for safekeeping. So it would be a similar role.
Yeah, okay. So that would be a simple solution, that a clerk or their delegate, because you do have two clerks, that can also resolve the issue to some degree, that if it relates to a clerk of one house, you could have a protocol where the clerk of the other house did the privilege advice. But so a clerk or their nominee, which would allow you to delegate to another clerk or a former clerk or something that was associated to the parliament to resolve that, might be suitable.
Agreed.
And just in relation to your two options, I mean, I'm attracted to putting the issue beyond doubt that privilege applies to the TIA Act, which is really what we're talking about. And it's not a complicated amendment. I would have thought that simply tweaking or adding a clause into the NAC bill would be quicker and easier, given that's the bill that's before the parliament. It's an amendment which presumably could be quickly drafted and popped through with the bill. Would be simpler than amending the TIA Act.
I think the actual amendment would be pretty simple either way. The NAC consequential bill, which is where this item that the committee is looking at lives, that could easily be tweaked to have have those words put in there. But I think you might find that because so many different agencies exercise powers under the TIA, it would be appropriate to have consultation with more agencies. I'm sure that would slow the process down beyond the timeline that's envisaged for passing the NAC. So the idea that you might drop something into the NAC bill itself at this point in time and look at the broader issue of the TIA in relation to the electronic surveillance reform program might be a better way of achieving that.
Yeah, okay. Thank you. That's very helpful. That gives us a little bit of a steer between your two options. That and we've got to make a choice and a judgment as a committee. I suspect if we want to have any impact on this, we'd need to form our view in the next few days so it can attach to the legislation next week and not overly complicate it. If we want to have the perfect answer and take time, then the ledge, I suspect, will find its own way through. But that gives us a useful steer on which we might want to jump if we actually want to address the issue quickly.
Thanks, Mr. Hill.
Sorry, just one final question. Just on the first point that I queried you on, the idea of a sort of an advocate, be it the clerks or their nominee, does that need to be in legislation, or is that something that could be the subject of the protocols between the parliament and the investigatory agencies?
In the absence currently of any protocols, I think that's not really an option. But if you did, if there's when the search warrant protocol was updated at the end of the last Parliament, statements were made in both houses by the then presiding officers to say, well, let's revisit the question around covert searches in the current Parliament. So the presiding officers will no doubt be doing some work, are doing some work in that space at the moment, will no doubt update the Parliament on that at appropriate times. But in relation to the search warrants, for instance, we have had situations where we've envisaged either the presiding officer or the relevant privileges committee engaging someone to undertake a kind of oversight role in relation to privilege. So that might be a way of doing it absent a protocol, doing it via the privileges committees or something or the presiding officer of the relevant house.
Okay. Thanks, Chair.
Chair, can
Thank
I
you,
jump
Mr.
in
Hill.
there, please?
Who's that? I can't see.
It's Andrew Wallace.
Oh, Deputy Chair, you're not up on the screen, so I'm sorry I didn't go to you straight after my questioning, but please go ahead. I can't see your box, but anyway, go ahead.
That's right. So I think I was the presiding officer for the House of Reps when that MOU was, I think it was my first job on my first day, if I remember correctly. So from my perspective, if I can just throw in my two bobs worth as a previous presiding officer, I totally agree with Senator Patterson's view about the perceived lack of independence of a presiding officer, and I think that would be absolutely fraught with danger. We don't. The reality is we do not have an independent Speaker or President, and if the presiding officer was called upon to act as an advocate for a person who is the subject of a covert warrant, wow, that would just be disastrous for, more likely disastrous for the presiding officer, but potentially for the person who's the subject of the warrant. That's a lose-lose situation. So we shouldn't be looking at that in any way, shape or form, in my view. As to who would make that decision, Richard or Peter, can you draw upon any experience anywhere in the world where a clerk of a chamber would be called upon to make that decision? I have to say I'm uncomfortable about handing clerks that power.
I think you should be uncomfortable about handing clerks any power, Mr. Wallace. No, the view that we've always taken is that questions of privilege are for parliaments to determine. So the relevant house must determine the question. What we're really looking at in this particular space, though, is assisting agencies to get a sense of whether they're going to trespass on privilege in relation to investigations that they're undertaking. It may well be that an agency will say, okay, we will curtail our investigations in a particular space, given that we have advice that we might be entering difficult territory. Or an agency may well say, actually, in the circumstances of this matter, we think that trampling over privilege is warranted, and we will come back and explain ourselves to the Parliament at a later stage, at an appropriate stage. They're difficult concepts to get on board because they do seem to clash with our understanding that, parliamentary privilege exists as a constitutional right of the Parliament. But they're the sorts of conversations I think would be had by an advocate, whoever that advocate is, rather than suggesting that the advocate be somehow delegated the power to determine how privilege applies in that space, because properly speaking, that power is a power that belongs to the relevant House.
Okay, so doesn't that link back into your first point in your submissions about having a properly formulated MOU? And you say in your subs on that first point that it's important that there's clarity about the interaction of privilege and the statutory powers. Does the current MOU, which I signed off on the 23rd of November 2021, does that not is that not adequate? And if it's not, assumedly that it needs amending.
I think, Mr. Wallace, the MOU that you and then President Brockman signed off is perfectly adequate, but it exists in the limited space of search warrants being executed by the AFP where privilege might be involved. So it doesn't go to the exercise of powers by agencies other than the AFP, and it doesn't go to the exercise of powers other than the seizure of material under a search warrant, which is really why, after quite lengthy and detailed discussions on those extended matters over the last Parliament, you made a statement to the House and Senator Brockman to the Senate saying we've agreed in our MOU that more work needs to be done in those two spaces in the next Parliament, and that work, as I say, is now underway.
But by virtue of the fact that the MOU really is only exclusive to the AFP, that the MOU needs to be updated for an investigation that might be undertaken under the NAC.
Yeah, I think so. Mr. Wallace. I think that's there ought to be a standalone protocol between the NAC and the Parliament in the same way as has been recommended in relation to state parliaments and state commissions. And the idea of it will be relatively easy, I'd suggest, to develop a protocol in relation to things like notices requiring the production of documents, but it will be a more difficult set of questions involved where you're looking at the issue of the exercise of covert powers for all the reasons that many of you have discussed today.
So if we discounted the presiding officers stepping in as an advocate, and for the sake of this argument, we discounted clerks, where does that leave us in your view?
It's a good question, Mr. Wallace. I think that's the sort of conversation that the working group in the last Parliament had, and no doubt that will be part of the discussion between the presiding officers and the Attorney General in the current Parliament.
Unfortunately, you don't have that luxury. Sorry, a decision needs to be made on this. But sorry, Chair, I'm just running short on time.
Sorry, just on that, Deputy Speaker, I was just going to say, the earlier part of our conversation did touch on other options like a public interest advocate. I think you might have mentioned some former clerks that could fill the role. Someone independent, I guess, of the presiding officers and the current clerks. But yeah, it's a discussion to be had.
I think that's right, Chair. Thanks so much.
Thanks, Deputy Chair. We are almost out of time. I don't think there are any other questions. I don't see any other hands up. Did you have any further questions, Deputy Chair? Sorry.
If we're almost out of time, no one's got their hand up. I don't appreciate being shut down.
Chair, this is Andrew Hasty here.
So one at a
Chair,
time,
Andrew,
I'm
Andrew.
getting different voices.
I'll go
Deputy
ahead.
Chair, do
very
you have
quickly,
further
Chair.
questions? Deputy Chair, do you have further questions?
Andrew Hasty, go for you. I didn't realise you had some questions. Andrew, go for your life.
Okay.
No,
all right.
I just want
Andrew?
I just want to associate myself on the public record with the questions put by Senator Patterson and his concerns.
Okay. Thanks, Mr. Hasty.
Thank you.
Thanks, Deputy Chair. Thanks, Mr. Hasty. Thank you to both of the clerks for appearing today. If there is any...
Chair,
Thank you
can
very
I just
much.
ask another... Chair, I would just like to ask a clarifying question, please.
Please go ahead. That's what I was asking, if you had any further questions.
Richard or Peter, can I just get it very, very clear from you? Julian Hill put a proposition to you about, there being some sort of alternate arrangement where, if the subject of the warrant was in the House of Reps, then the matter could go to the Clerk of the Senate and vice versa. There are also other options about previous clerks, but putting that aside for the moment, is it your position that that there would be a degree of discomfort about the clerks being put in that position, and that position could really only be done by legislation, couldn't it?
I think, firstly, I don't want to disassociate myself with comments made by any of the members of the committee, but I don't think that it would be appropriate for a matter involving a senator to go to the Clerk of the House and vice versa. I think that raises all sorts of problems with comity between the two houses. So I didn't pick up that detail when that was raised earlier. I don't think that I would have any discomfort around the idea that I might be providing advice myself in relation to these matters, other than making sure that if questions are coming from two sources, then it would be appropriate for me to delegate that role to someone else in some circumstances. I think that it would be possible to use a process other than legislation to appoint somebody to provide advice in these matters, but probably an independent statutory officer is the best way to go in many ways. And if you are setting up, parliamentary standards commissions and things like that, it may well be that that provides you another place to look to put that expertise.
Thanks, Chair.
Thanks, Deputy Chair. Thank you both for your attendance today. If you have been asked to provide any additional information, the Secretariat will be in touch, read timeframes for providing that to the committee. You'll be sent a copy of the transcript of your evidence, and will have an opportunity to request corrections to transcription errors. Once again, we thank you on behalf of the committee for your attendance today and your evidence.
Thanks so much, Chair.
Thanks, Chair.
Robert, I think we've got our next witnesses who are already online. Is that correct?
That is correct, Chair. I can see Ms. Atkinson, and I did see Mr. Reeve. So I think, you can kick off. Actually, there they are. They've popped up. So yes.
They're both here. Excellent. Thank you. We'll keep going. I now welcome the representatives of the Attorney General's Department to give evidence at this public hearing today. For the Hansard record, would you each please state your full name and the capacity in which you appear before the committee?
Thank you, Chair. Lucinda Atkinson, Assistant Secretary, Fraud Prevention and Anti-Corruption Branch at the Attorney General's Department.
And Parker Reeve, Director, Fraud Prevention and Anti-Corruption Branch, Attorney General's Department.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as the proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. So, Ms. Atkinson and Mr. Reeve, do you have an opening statement that you wanted to give before we start asking you questions?
Yes, thank you, Chair. The Attorney-General's Department welcomes the opportunity to appear before the committee as part of its review of an amendment to subsection 110A1 of the Telecommunications Interception and Access Act 1979, which is included in the National Anti-Corruption Commission Consequentials and Transitional Provisions Bill 2022. The National Anti-Corruption Commission will be a specialist anti-corruption agency with broad jurisdiction to investigate serious or systemic corruption involving Commonwealth ministers, parliamentarians, and their staff,
I'll be done in a bit. Okay, tough.
statutory office holders, employees of all government agencies and contractors, as well as any person who engages in conduct that could adversely affect the honesty or integrity of a public official's exercise of their functions, duties, or powers. It is common for persons engaged in serious or systemic corruption to take significant steps to conceal or obfuscate their activities. Together, the NAC legislation will provide the Commissioner with strong investigative powers similar to those of a Royal Commission to uncover the full extent of the evidence relating to alleged corruption. Collectively, these powers will enable the Commission to obtain information about corruption that would otherwise be unobtainable. The Consequential and Transitional Provisions Bill would amend paragraph 110A1C of the TIA Act to transfer the Australian Commission for Law Enforcement Integrity's existing powers to access stored communications and telecommunications data to the National Anti-Corruption Commission. The Commission's access to these powers will be provided on the same basis as ACLI and state anti-corruption commissions, including the same thresholds for the issue of warrants and authorisations. These powers would enable the Commission to obtain documentary evidence that would be relevant to a criminal corruption investigation, such as contemporaneous text messages or emails held by carriers and carriage service providers, and evidence indicating that persons of interest have or have not been in contact with one another. The Commission's use of powers under the TIA Act will be subject to oversight by the Commonwealth Ombudsman, consistent with the existing arrangements for all Commonwealth, state and territory law enforcement and anti-corruption agencies that use these powers. Several of the submissions made to the committee on the proposed amendment raise concerns and recommendations about the way the TIA Act operates for all Commonwealth, state and territory agencies, including but not limited to the Commission. As noted in our submission, the Attorney-General's Department is leading a major reform of Australia's electronic surveillance laws in response to recommendations of a comprehensive review of the legal framework of the national intelligence community. The Department considers that broader issues with the TIA Act would more appropriately be addressed through that process.
Sorry, Ms. Atkinson, can I just ask you to pause for a moment? Someone's just put them on mute and music's coming through. If I could ask members and others who are on this call to just put themselves on mute and make sure there's no music flowing through from their phone or their laptop. Sorry, Ms. Atkinson.
Thank you, Chair. Continue. The Department considers that broader issues with the TIA Act would be more appropriately addressed through that broader reform process, which will consider access to and use of relevant powers by all the agencies, including the Commission. The Government will continue to work with stakeholders to develop draft legislation to implement these reforms for release and public feedback prior to consideration by the Parliament. The Government has also indicated that it considers that improved protections for press freedom are needed and that it intends to progress further legislative reform in this area. The NAC Bill itself contains strong protections for the identity of journalistic sources in relation to the powers provided in the NAC Bill. The Commission's powers under these laws, including the TIA Act, will be subject to existing additional safeguards, including the Journalist Information Warrant Framework in Chapter 4 of the TIA Act. The Government is expediting implementation of the recommendations of this committee's 2020 inquiry into the impact of law enforcement and intelligence powers on the freedom of the press, and considering the 2021 Senate Environment and Communications References Committee inquiry into press freedom. Thank you again, Chair, for the opportunity to appear. We're happy to answer your questions.
Thank you very much. I might start off by asking about, and this pertains to one part of your submission, but it's a broader question, I guess. The commissioner under the NAC would be able to commence investigations when they consider or are of the opinion that what they're investigating would involve serious or systemic corrupt conduct. And it includes, but is not limited to, conduct that would constitute a criminal offence. Could you describe for us or explain to us how you would define what is being stated as non-criminal corrupt conduct?
Thank you, Chair. I might make some opening remarks and then pass to my colleague, Mr. Reid. As you've noted, the Commission will have jurisdiction over both criminal and non-criminal corrupt conduct, but will only be able to launch an investigation into a matter that the Commissioner considers to be serious or systemic corrupt conduct. So those terms are not defined in the bill, but would take their ordinary meaning. And I suppose the reason why that threshold is there for investigations is to ensure that the Commission is appropriately targeting its investigations to the most serious matters. In terms of what might constitute a criminal act of corruption versus a non-criminal act of corruption, there will obviously be matters that are covered by the criminal code in terms of the offences of abuse of office, for example, or fraud, or dishonestly obtaining a benefit. In terms of the non-criminal acts of corruption, that might be matters that would involve, for example, a breach of the public trust. But it might be just relevant to point out in the context of this particular inquiry that the powers that this amendment would provide the Commission would only be able to be used in relation to a serious contravention, which includes a serious offence with significant penalties of imprisonment.
So that point, though, it's an important point, because not to have a crack at politicians, but they tend to breach public trust a lot when they break promises and do all sorts of things that, promises made in elections and whatnot. But it sounds like when you're talking about serious and systemic corrupt conduct, by definition, that would most likely, or the majority of cases, would be investigations into something that would frankly fall within the criminal definition of criminal corrupt conduct. I'm just wondering, are there any examples here? You said non-criminal corrupt conduct would be a breach of public trust. That's a very open and vague kind of phrase. What does that entail?
Thank you, Chair. So, in broad terms, the concept of a breach of public trust is the use of an official power by a public official for a purpose other than which the power was granted. So, that may be taking a decision under a statute where it might be a minister or a public official is given the power to make a particular decision for particular reasons, and making that decision for an improper purpose, being a purpose that is not within that statutory framework.
And which would not be designated as a criminal offence, or potentially a criminal offence. Or it could be, but
it could be. I think, as Ms. Atkinson mentioned, there are offences in the criminal code for misconduct in a public office and the like, which, where the criminal threshold is met, could result in criminal liability for an official for misusing their powers. But obviously, there would be a range of circumstances where the conduct in question would fall short of the criminal threshold, but would be nevertheless, potentially quite serious matter of administrative law, the misuse of power, or the exercise of power for an improper purpose, that in another context, could be reviewed by the courts or by the Administrative Appeals Tribunal, for a failure of proper decision-making processes. But if it was done for an improper purpose, for a corrupt purpose, could also constitute serious corruption within the Commission's jurisdiction.
So I'm trying to zoom in here on what I think is a really important point, which is that there may be actions taken by public officials that would be deemed to be non-criminal corrupt behaviour based on what you're describing there, and those actions would be investigated if they are of a serious and systemic nature. Is that right?
That's right, Chair. So I suppose in a practical sense, obviously, it will be a matter for the Commissioner to determine what the Commissioner considers to be serious or systemic corrupt conduct. But the importance of that threshold is really to ensure that the Commission is focusing its attention on the most serious matters. So this is similar to, not exactly the same as, but similar to the threshold that currently exists for ACLI, the Australian Commission for Law Enforcement Integrity, under its legislation, where it is required to prioritise the investigation of serious or systemic corrupt conduct. And I suppose the thing with corruption investigations that the experience of ACLI and state commissions draws out is often it will be difficult to tell at the very outset the exact nature of the conduct that's in question, and it could be that an investigation is launched, and as the investigation proceeds, there isn't evidence to a criminal standard of corrupt conduct, but the Commissioner may be nevertheless satisfied that at an administrative standard that that conduct constitutes corrupt conduct within the meaning of the Act. So I suppose this is reflecting the fact that the Commission is really there to uphold integrity and the highest standards of conduct by all public officials. And while it will, presumably focus most of its attention on criminal activities, that in fact that there are matters that may not reach that standard, which still amount to corrupt conduct.
So, no, sorry, and I missed part of the answer. I apologise because my computer froze for a moment. But we're talking now about this power to surveil and so on under paragraph 110A and so on. The threshold test is quite important because when you get to that decision point, the Commission is going to be deciding whether to exercise this power that we're looking at under the TIA Act. And so I'm just trying to get this clear in my mind that they would be looking to exercise that power to commence investigations if they've got this clearly in front of them, prima facie, a kind of a systemic or serious evidence of some corrupt conduct. It could also be non-criminal corrupt conduct in the way that you've described. I guess the next question would be is if you would proceed through that type of investigation, if the conduct was found to be didn't fit under any particular criminal code, you're saying that there may be sanctions or penalties under some sort of administrative law. Is that right? Like that would be the end point of an investigation into what we're terming non-criminal corrupt conduct, a breach of administrative law?
So, Chair, I think to your point, at the end of an investigation, if the Commissioner is satisfied that there is evidence of a criminal offence, the Commissioner can refer that to the DPP or the AFP or another appropriate agency for action. The Commissioner also will be required to issue a report on finalised investigations, and as part of that report, the Commissioner can make findings in relation to a person's conduct, which can include a finding that the person has engaged in corrupt conduct, or as well that a person has not engaged in corrupt conduct.
Or in that first part, if they've in the finding it says they've engaged in non-criminal, like they haven't found a criminal offence to refer that person's conduct, in the finding itself they can say we're of a view that this is corrupt conduct, but it doesn't fit any criminal code in the land, whether it be state or federal, but nonetheless the finding is that it's we consider this to be a breach of public trust or whatever it might be in the wording, and that in itself is going to be the sanction, because there's no law that would set, there's no penalty, there's no criminal offence to be referred to.
I think that's right, Chair. If there is no evidence that would meet that criminal threshold of proof, then the alternative is for the Commissioner to issue a finding that the person engaged in corrupt conduct. And the key difference there is the standard of proof that is required. So obviously in a criminal case, you're looking at proving something beyond reasonable doubt, whereas the administrative standard is slightly lower. So it could, in fact, be the same type of conduct that would, at a higher standard of proof, be relevant to a criminal proceeding, but it just could be that there isn't that level of definitive proof available to the Commissioner.
But nonetheless, there'd still be a finding and it would be made public.
It can be made public, so the Commissioner can consider whether it is in the public interest to publish a report at the end of an investigation, and in that report to include the findings.
So my last question, I'll hand over to, I think Senator Patterson's putting his hand up, unless the Deputy Chair's there, but I can't see him. The threshold test to commence an investigation using these powers would really relate to whether the Commissioner believes that the evidence before them prima facie goes to serious and systemic corrupt conduct, but it could also mean that doesn't necessarily get referred to a criminal at the end of an investigation, that there's a criminal offence that it could be referred to the DPP. It could be a finding based on what the Commissioner considers to be non-criminal corrupt conduct, and that could be either public or a private report or a confidential report. Is that right?
Chair, I think it's important to differentiate between the decision of the Commissioner to commence an investigation and then the thresholds that would apply to access these powers that are provided by this amendment, which are different kind of standards.
Yeah.
I think it is important to note that in relation to these powers in particular under the TIA Act, the thresholds are very significant, and the issuing authority or the authorised officer, depending on which power you're looking at, would need to be satisfied that there's reasonable grounds for suspecting that the carrier or the communications will be relevant to the investigation of a serious criminal offence.
Right. Yeah. That's an important distinction. Thank you for that, Ms. Atkinson, because when we're looking at this particular power, it's quite significant powers. And I think, when you're using these powers, obviously the seriousness of the conduct that's being or about to be investigated I would think it'd have to be a very high threshold. And you're saying the way it's drafted now, it would really almost definitely be criminal, almost a criminal matter, effectively.
Yes, I think
it would absolutely need to be.
Yeah,
it would need to fall within the definition of a serious contravention in the TIA Act, which an offence punishable by at least 3 years imprisonment, or there's a few other limits, but that's the primary one.
Yeah, you know what I'm getting at here is, like, if a Commissioner was going to use these powers, you would be, we'd want to question about whether, they're using these powers to investigate someone who breached public trust. Pretty clear that it's not going to be a criminal offence, but it's in that grey space of, this is non-criminal corrupt behaviour. It's serious, but there's no criminal code that covers it. Using those powers is quite a significant step in investigating that kind of behaviour, if you like.
And Chair, I think that's exactly right. These powers will only be available in those very most serious of cases. Right. And the issuing authority or the authorised officer will need to be satisfied that the evidence that would be attained would go towards proving a criminal offence.
Thank you. Deputy Chair, are you online or on the phone?
Yes, I am.
Do you have questions? Sorry, you're not up on the screen, so it just doesn't seem that you're with us, but you are on the phone. Do you have a question?
No, I'm on the phone, yeah. Yeah, I do have a couple of quick questions, and I'm going to have to jump off.
Okay, go ahead. Thank you.
Following on from your line of questioning, Chair, I'm still not quite clear as to what would amount to corrupt conduct that is not criminal corrupt conduct. I'm just wondering if the witnesses can just provide a bit more expansion on that.
Certainly, Deputy Chair. I mean, perhaps to give a couple of examples and then circle back to the headline question with a bit of illustration. One example of potential, I mean, it'd be a matter for the Commissioner, obviously, if I can sort of start the answer with that caveat. One example might be an abuse of office by an official to pressure a more junior official to make a particular employment decision, hire a staff member that is a family member, a friend, a person with whom the senior official is in a relationship with. That would be an abuse of office. That would be a misuse of that person's power as a senior official to pressure a junior official to make a particular decision. It would be for an improper purpose, and so it would potentially constitute corrupt conduct. And those are matters that have been investigated by corruption commissions in the past, and could constitute serious or systemic corrupt conduct in all of the circumstances. It is possible that conduct could constitute a criminal offence, but I think at face value it is probably less likely that it would either constitute a criminal offence or, even if it might, that it would be referred for prosecution. I think those sorts of matters would ordinarily be dealt with as a disciplinary matter by the agency as, a serious misconduct by a public official and serious corrupt conduct by the public official, but not necessarily as a criminal.
Go ahead, keep going. Sorry, keep going. Hello, can you hear me?
So, yes. Sorry, Deputy Chair. So I think the broad principle here is that corrupt conduct is conduct that falls within the definition. So it's an abuse of office, a breach of public trust, conduct that could adversely affect the honesty of public officials' conduct. Much of that conduct could also constitute a criminal offence, but I think as Ms Atkinson has said, in some cases that will just depend on either the severity of the conduct in question or the evidence available. But in other contexts, for example, and sort of nepotism is a potential example. There may not be a criminal offence available, but it would, I think, most likely constitute serious corrupt conduct on any reading of the situation and with any of the bill.
So would it be fair to say that the provision of the Commission making a finding about non-criminal corrupt conduct and corrupt conduct is more around the standard of what might need to be proved in a criminal court? Would that be fair to say?
Deputy Chair, I think that's right. I think the other thing to keep in mind is that those findings are made at the end of an investigation. So they're not relevant to whether or not, to the decision whether or not these TIA Act powers in particular would be available.
Sure.
After the full investigation has been completed. And yes, at that point it would be about what standard of proof the Commissioner is satisfied can be reached, and obviously the seriousness of the conduct that has been shown out by evidence would go to whether or not the Commissioner will provide evidence to the CDPP for prosecution.
I just have some philosophical concerns about a decision being made by the Commission that someone is has been found to have taken part or taken part in corrupt conduct, but it doesn't meet the criminal threshold. I mean, that will be life-altering for that individual. It will destroy their career. So it's more of a philosophical thing from my perspective, but I'm probably making more of a statement than a question. Can I take you to the issue of the stored communications as opposed to the accessing telecommunications data? So am I right in my understanding that under the TIA, under Section 116, an issuing authority is a judge, magistrate or a member of the AAT, but under 110A1C, so accessing telecommunications data, that approval can be given by the Commissioner himself. He doesn't need to go to a court or the Administrative Appeals Tribunal.
So, Deputy Chair, the amendment to 110A 1C would list the Commission as a criminal law enforcement agency. That definition is relevant to two different powers in relation to stored communications power. Those warrants must be issued by a nominated judicial officer or AAT member. So I think if that's your question in particular, no, they could not be issued by the Commissioner. Those warrants must be issued by the nominated judicial member or AAT member.
Movement and light.
Thanks. That's a lovely way to me, Andrew.
I'm now joined by Mr. Hill. He's jumped into my car. So, I'm sorry about that. I didn't hear your last answer to that question. I'm trying to determine whether the Commissioner will be able to access communications data of his or her own volition without going to a court. Is that correct?
Deputy Chair, no. The stored communications warrants can only be issued by an issuing authority, so that's a nominated judge or AAT member.
Yep. So that's the stored communications. But what about the data? Is it because in your submissions you say accessing telecommunications data as a criminal law enforcement agency under 110A1C of the TIA Act. The Commission would also be an enforcement agency under Section 176A and able to authorise access to telecommunications data under Chapter 4. So, you know where you're going?
No.
Then Deputy Chair, that's correct.
Main road, you go down the hill and you climb up the hill. Yeah. Turn right onto
Sorry, we're at a defence base.
Chin Road, second building on your left-hand side, that's 103.
Can I, Deputy Chair, can I just ask you to put your thing on mute so we can...
Okay. Thank you. I've got
Deputy Chair, I'm going to go to another witness. I'm going to go to another member.
Yeah, why don't we go to...
Could you put your phone on mute?
Let's go, James.
Can you put your phone on mute so we can continue the hearing? Thank you. Senator Patterson, please.
Thanks, Chair. Appreciate that. I have 4 matters which I'll try and move through as quickly as possible because I know we've got limited time. Firstly, I'm not sure if you heard the evidence with the joint clerks in relation to privilege. My question is, if a member or senator's is subject to a warrant under the TIA Act, which will be covert, how will they have an opportunity to claim parliamentary privilege?
So thank you, Senator Patterson. Might be worth noting our view, I think, aligns quite nicely with the clerks. We also do not think that this amendment would abrogate parliamentary privilege.
That's not my question. Sorry, that was a separate issue. Not pursuing that issue.
In terms of how parliamentary privilege then is protected, we're also anticipating that an MOU will need to be agreed between the Commission and the presiding officers in a similar vein to the AFP's existing one and to the ongoing discussions there in relation to covert powers. That MOU would set out the process that needs to be followed in order to ensure that the privilege is not abrogated in relation to any material that is collected. And ultimately, obviously, it would be a matter for the courts to adjudicate that protection.
But I'm just interested in how does the department envisage that a parliamentarian would make a claim of privilege when they're subject to a covert warrant under this amendment?
Well, I think, Senator Patterson, that the issue will be the same for the Commission as already arises for other law enforcement agencies that have access to these powers. and needs to be the subject of an agreement about the process for that to happen.
So there's nothing in either the bill that's before this committee or the main Anti-Corruption Commission bill that deals with this issue or provides any protections for a parliamentarian to claim privilege. It will have to be resolved by the Commission and the Parliament after the legislation passes.
That's right, Senator Patterson, and I think that is the case, as I say, for other law enforcement agencies that are subject or that exercise these powers at present. And it's also a matter that will be considered as part of the department's electronic surveillance reform process.
Yes, I said in error that it was a Home Affairs process earlier. It used to be a Home Affairs process. I recognise it's now an AG's process. But that doesn't give me confidence that if the committee signs off on this bill and it passes, that protections will be put in place, because it's reliant on the Commission, which will be independent and not be able to be directed by a government, or indeed the Parliament, once the legislation is established, to establish an MOU.
Sorry, Senator, was there...
I'll phrase that as a question, perhaps. Would the department have any concerns if the committee recommended an amendment to the Act to ensure that this is dealt with, either by establishing a public interest advocate who fills this role, or the presiding officers, or the clerks, or a delegate of the clerks? Would the department have any concerns?
Senator Patterson, I think just in general terms, because this is an issue that exists for any agency that exercises covert powers in relation to material that might be subject to this privilege, our advice would be that it would be more preferable to deal with it as a whole as part of the electronic surveillance reform process, as opposed to just singling out the use of these powers by the Commission, and that in the meantime a protocol agreed between the Commission and the presiding officers is the most practical way to deal with the issues of process.
When do you think the ESR process will be concluded?
I think, Senator Patterson, we might need to take that on notice. I understand that the process is well advanced, and that the proposal, the aim is to have draft legislation available for public consultation prior to going into Parliament next year.
Okay, thank you. I'll leave that issue and move on to some other issues. I want to pursue this issue of issuing authority, which has been kind of briefly canvassed. In the previous Parliament, in 3 different speeches delivered by the then Shadow Attorney General, one on the 12th of February 2019, one on the 6th of December 2018, and a third one, which date I'm just finding now, on the 28th of November 2019, the then Shadow Attorney General called for the issuing authority for TAA Act warrants to be a judicial officer. It specifically said, and I quote, "At present, the measures introduced by the Assistance and Access Act do not include that form of judicial oversight by requiring judicial warrants for their exercise. As a matter of principle, the Attorney General does not believe that a senior police officer should be given the power to compel an innocent third person, including a law-abiding Australian technology company unconnected to an investigation, to provide a technical assistance warrant without a warrant." Why, given that that's the Attorney General's view, which is articulated many times, why is that not reflected in the legislation before us now?
So, Senator, I think, again, this is another issue that will be considered as part of the electronic surveillance reform process. As you've noted, this is not an issue that is specific to the Commission, and the Commission will access the powers by this amendment on the same basis as all other agencies. And the issue of who should be a nominated issuing authority will be considered more broadly as part of that broader review.
But if the committee was concerned to address this and not wait for the ESR reform, I think we should consider this now, and I suspect that will be at least some members of the committee's view. One of the reasons why it might not be desirable to have a member of the AAT to consider these warrants is that AAT members have a fixed term. AAT members often seek reappointment, and if they are not reappointed, AAT members often seek other forms of employment. If during their time on the AAT they are asked to approve warrants for accessing the communications of a member of parliament, which is a sensitive thing that hopefully they won't do very often, but might do from time to time, they'll be in possession of highly sensitive information, which they will carry with them for the rest of their lives. And they will also be mindful that if they're seeking reappointment to the AAT, that they might feel pressure to make a decision which is favourable politically to the government of the day, whoever that might be. That's one of the reasons why I think it would be more appropriate for a Superior Court judge to have that role, because they don't have to worry about reappointment, and it is an appointment for life, and they may not have no professional obligations after they retire. What concerns would the department have if the committee recommended a Superior Court judge fulfil that role instead of an ordinary member of the AAT?
So I think perhaps this is a threshold matter. It's probably worth noting that the TI Act itself does contain confidentiality obligations for people who receive information about warrant applications. So the further use of that information by a member of the AAT would be subject to those existing confidentiality obligations in the Act, which attract criminal penalties for a breach. I think more broadly, Senator, this is an issue that would require consideration of how the warrant framework works as a whole for the TI Act, and presumably for other similar powers, the Surveillance Devices Act and similar covert powers across the statute book. The ability for AAT members to issue warrants was introduced in 1997, I believe, if I recall correctly, following a High Court decision in Grollo and Palmer that clarified the circumstances in which members of the judiciary can issue warrants, requiring their personal consent and the like. So I think the potential concern would be that simply just making sure that any transfer of that responsibility from the members of the AAT, who do issue the majority of telecommunications interception warrants and surveillance devices warrants, to the judiciary, was done in a way that didn't limit access to issuing authorities for agencies seeking to investigate serious criminal offences.
Thank you. I'll just jump in right there because I do understand that point. It is a relevant point that's been made by your Home Affairs predecessors to this committee repeatedly. And typically when they advance that argument, they say that they're anticipating that the volume of warrants to be issued under the relevant act is going to be so voluminous that we couldn't possibly restrict it to just being Superior Court judges. There are too few of them. We need a larger pool of issuing authorities, for example, AAT members, to draw from. How often do you think it will be the case that an issuing authority is asked to issue a warrant, for example, on a member of the National Security Committee of the Cabinet or a member of Parliament?
Senator, I mean, it's very difficult for us to kind of make that assessment in the absence of lived experience. I suppose at a really general level, if we look at the experience of the Australian Commission for Law Enforcement Integrity, which is the existing Commonwealth level anti-corruption agency, over the past 3 years, ACLI have made 2 applications for stored communications warrants, 831 applications for disclosure of telecommunications data, and 162 authorisations for the disclosure of prospective telecommunications data. ACLI's jurisdiction is obviously much more limited than the National Anti-Corruption Commission's jurisdiction would be, so we would anticipate that the volume of the use of these powers would be significantly larger for the Commission.
So sorry, those figures, were that an annual figure?
They were over the past 3 years, and those figures are in ACLI's submission to the committee.
Right. What are the annual figures?
I don't have the annual figures to hand, Senator, but we can provide those on notice.
Because I think this is a relevant issue. If it's going to be a dozen times a year or a couple of times per month, that's one issue. If it's going to be 1,000 times a year, then that's clearly a whole different category. And if I would submit that if it's well beyond 1,000 a year, okay, maybe there's an argument that you need a broader pool of issuing authorities. But if it's going to be in the dozens, or I suspect even less than that, I think I hope, given the thresholds required, as you noted under 5A of the Act, that it has to be a criminal matter of 3 years in jail or more, that this would be an extremely rare event and it might only happen once or twice a year, in which case I don't see the harm in restricting it to a smaller pool of judges, or the Superior Court judge, for example.
And I think, Senator, we can't predict with any great certainty what the level of usage by the Commission would be.
Okay. Moving on to some other matters, the Attorney General has publicly said that unlike a state anti-corruption commission, it's likely that the NAC will come into contact potentially with classified material. And in addition to possible classified material, it will come into contact with the other material which is not classified but which will be sensitive in nature, would be of great interest to a foreign intelligence service because it will involve potentially compromising material on senior members of the Australian Defence Force or Parliament or indeed the Cabinet or the public service. I'm interested to know what protections the Commission will have in place to protect that sensitive information. So firstly, could you outline the cyber protections that the Commission will have in place?
Thank you, Senator Patterson. I'll note that there are a range of protections in the NAC bill itself in terms of the use and protection of that information. But from a practical perspective, the Commission, I think, will be very acutely aware of the sensitivity of the information that it collects and uses. The Commission will have a protected level ICT environment as well as access to higher level classification systems to facilitate engagement with that higher level of classified information. The Commissioner will also be will also enter into agreements with intelligence agencies in particular in terms of the protocols around dealing with investigations that relate to those agencies. And we also anticipate that the Commission will have very highly cleared, security cleared staff who are...
Thank you. I'll come to that. That's a separate issue I want to pursue. You said that the NAC systems will be at the protected level and that there'll be possibility of higher levels of protection. I mean, the protected level is the most basic level of protection. It is kind of, just standard for government departments. I would be concerned if that was the starting point. I would hope the starting point would be much higher than that. What information can you give me about that?
So, Senator Patterson, obviously, as a PGPA Act entity, the Commission will be subject to all of the requirements of the Protective Security Policy Framework, and that framework sets out the required levels of protection, including false cyber stance, and the Commission, its systems and its facilities and its staff will be aligned to that in terms of the sensitivity of the information that is to be protected. In terms of the various levels of maturity of cyber settings, the Commission's protected environment will be designed to meet the maturity level 3, which is the top level of maturity for cyber protection. And I suppose the Commission will also be working very closely with other agencies that deal with this type of very sensitive information on a routine basis, and will, where necessary, draw on their expertise to ensure that the information it deals with is properly protected.
Thank you. I do appreciate that, but as you would be familiar, the ANAO has repeatedly found that government departments have failed to comply with the Essential 8, and it is, I know, a great source of frustration for the Australian Signals Directorate that the advice that they provide to departments is not binding and often not complied with. So why should we have confidence that the Commission will be better than other government departments which often fail to meet those standards?
Well, Senator, obviously, ultimately, this will be a matter for the Commissioner to be satisfied of, as in their and the Chief Executive Officer of the agency in their role as the accountable authority. But in the meantime, the Attorney General's Department and ACLI, which will become part of the NAC, are working very closely together to ensure that the NAC is positioned with the secure facilities and infrastructure that it will need to operate in this space.
Okay, thank you. I welcome that. Moving on to that issue of vetting, which you mentioned, obviously an insider threat by a foreign intelligence service is a risk when you're dealing with this sort of sensitive information. What level of vetting will NAC employees be required to have?
Thank you, Senator. So again, ACLI will become the NAC, and so to a certain degree, ACLI's existing infrastructure and policies will be amended and uplifted to be suitable in that space. ACLI has very extensive pre-employment screening and security vetting requirements for its existing staff and is going through a process of re-evaluating those settings in light of the broader jurisdiction and particularly the interaction of the NAC with the intelligence services and other agencies that deal in that highly classified space. We anticipate that they will have a need for a group of staff who will be cleared to that topmost level, but the majority of staff will be cleared to at least an NV1, if not NV2 level. That
just to clarify, thank you.
Yes.
When you say you anticipate or you believe, is there any requirement in any of the legislation that will ensure that that's the case?
I think, Senator, there's not a requirement in the legislation for that, other than any requirement that the Commissioner may agree with intelligence agency heads, which is a power under the which is a requirement under the Act.
Well, I hope the Commissioner. Sorry, you go.
And so just to reiterate Ms. Atkinson's point from earlier, as a PGPA entity, the Commissioner and the Commission itself will be subject to the Protective Security Policy Framework, so staff accessing classified information will be required to have the security clearance to access information of the particular level of classification. So to access top secret information, they would need to be cleared to access information at that level.
Yeah, that's good. Although, as I said in my kind of preamble, I'm concerned about both classified and sensitive information because it will be sensitive information will be just as much of interest to a potential foreign intelligence agency. As a broader kind of theme of concern, this is appropriately going to be an independent agency. Once it is set up, if there are not legislative or other requirements that enforce these obligations on it, there won't be a way for government to make sure that it happens. So I'm just interested in whether there'll be any concerns from the department's point of view if the committee recommended requirements to meet certain thresholds. All staff must have APV, or all staff must have an NV2 or an NV1 or whatever.
I think, Senator, from a practical perspective, a requirement of that nature would introduce some very practical considerations for the agency in terms of recruitment and retention. Not all staff will interact with information at that very, very top level of classification, and rightly so, that information will need to be quite closely held and quarantined within the agency as well. But as I say, I think building on ACLI's foundation, there is a significant level of awareness around the sensitivity of the information collectively that the agency engages with, and ACLI and the department are working very closely with the AFP and ASIO in particular to understand that risk and threat picture that the Commission will be facing. And as Mr. Reeve points out, the CEO as the accountable authority will be accountable for ensuring that the Protective Security Policy Framework settings are met.
Great, thank you. I welcome that. Chair, I'm happy to cede to other committee members.
Thank you, Senator. Go ahead, Andrew.
Yeah, look, again, I don't want to relitigate the questions and issues that Senator Patterson has put. I just want to associate myself with them. And particularly the point around the Superior Court judge being the issuing authority for a warrant, and also about my concerns as well with the security of the information that the NAC will be gathering and the vetting of personnel who oversee that. I just think great responsibility is being given to the NAC, and we expect great things. I'll leave it at that. Thank you very much.
Thank you, Mr. Hastie. Do we have any other members wishing to ask questions?
I just have one final clarifying question I forgot to ask before, Chair. Just to confirm, it is a decision of the Attorney General to decide which members of the AAT are the relevant issuing authority. Am I right? They have to be designated by the Attorney General?
That is correct, Senator, yes.
And the only minimum requirements for the Attorney General to designate a member of the AAT to be able to issue a warrant under the TIA Act is that they are a lawyer and that they have 5 years of service.
I believe that's correct, Senator.
And no, you go.
No, I was just double checking the provision myself, Senator.
Yep, so I believe that's the case. So it wouldn't prevent the Attorney General designating an ordinary member of the AAT, that is not a senior member, not a deputy president, not a president. An ordinary member of the AAT can be designated, provided they are a lawyer and have 5 years legal experience.
That is correct, Senator.
Thank you, because before the other inquiry, when this was an issue, some witnesses asserted that it had to be a senior member of the AAT, but I don't see that on the evidence of the legislation.
Senator, we can check that, and if required, we can provide alternative information on notice, but I think we're in agreement with you.
Thank you. Thanks, Chair.
Thank you, Senator.
Yeah,
Thank you, Ms. Atkinson.
Chair, it's Simon Birmingham here. Can I just ask one
Sorry, Senator. Go
follow
ahead.
up from Senator Patterson there?
You're
No
on the phone.
problem. I'm not
I
visible,
understand.
so apologies for just cutting in.
Please go ahead.
Thank you. Can I just ask the officials there if the committee were to recommend essentially that a precautionary principle apply in relation to this question of who issues warrants and referred it to a Superior Court judge, can you see any issues other than the question of availability or timeliness that's being raised, which clearly, if that were to become a problem, could be fixed by small changes to legislation or resourcing considerations in courts?
Thank you, Senator. I think the broader issue is that these powers are not only available to the Commission, and so implementing a particular requirement for the Commission, which is out of step with the requirements that apply to other agencies, could potentially have outcomes that we haven't foreseen. And so I think for that reason, we would think it's more suitable to be considered as part of that broader review of electronic surveillance legislation.
They may be outcomes that you haven't foreseen, but it also sounds like they're outcomes that you can't particularly identify what they may be. And clearly, what we're dealing with at present is legislation before Parliament that we are considering on its merits and its circumstances at this point in time. If we were to take a more precautionary approach, given the overall powers and implications of the way the NAC operates, then that approach, along with existing provisions elsewhere, could equally be considered within the broader review, couldn't they?
Sorry, Senator, was there a particular question?
Well, yes, that if we took a precautionary approach in the NAC, which may then mean there was a lack of complete consistency across the agencies, there'd be nothing preventing whether or not consistency was meritorious or not being considered as part of a broader review, would there? We don't have to accept consistency today to be able to consider these matters under the broader review.
That's right, Senator. I mean, there would be nothing to prevent that from being considered.
Yeah. Okay. Thanks, Chair.
Thank you, Senator Birmingham. Thank you, Ms. Atkinson and Mr. Reeve, for your attendance today. If you have been asked to provide any additional information, the Secretariat will be in touch, timeframes for providing that to the committee. You'll be sent a copy of the transcript of your evidence, and we'll have an opportunity to request corrections to any transcription errors. Thanks again for attending today. The committee will now suspend the public hearing for lunch. The hearing will resume at approximately 1 p.m. So we'll see you then, colleagues. Robert, I'm going to give you a call separately if you're still online there. I'll give you a buzz on your phone in a moment. Thank you. Cheers.
Thanks, Chair.
See you at 1 o'clock, everyone. Thank you very much. Sorry for the delay. I had a bit of a technical difficulty there, but I just want to officially restart the public hearing and declare reopen the public hearing on the Parliamentary Joint Committee on Intelligence and Security for its review of item 250 of the National Anti-Corruption Commission Consequential and Transitional Provisions Bill. These are public proceedings, although the committee may agree to request to have evidence heard in camera or may determine that certain evidence should be heard in camera. The hearing today is being conducted by video conference for nearly all participants. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. Unless you are giving evidence from outside of Australia, it is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Parliament as a contempt. In accordance with the committee's resolutions of 7 September 2022, this hearing will be broadcast on the Parliament's website, and the proof and official transcripts of proceedings will be published on the Parliament's website. I now welcome Dr. Stoltz to give evidence at this public hearing today. For the Hansard record, would you please, Dr. Stoltz, I've already named you, but could you give your full name and the capacity in which you appear before the committee?
Thank you,
For the
Chair.
record?
My name is Dr. William Stoltz. I'm the Policy Director at the National Security College at the ANU, and that's the capacity in which I'm appearing.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Dr. Stoltz, would you like to make a few opening remarks before we get into questions?
Thank you, Chair. Nothing at great length. I know that the terms of reference for this inquiry are pretty tight. I guess just for your benefit and others on the call, perhaps just to quickly run down, I suppose, the core thrust of my submission, which is really drawing attention to the potential interaction of the interception powers afforded under this Act with cabinet. Sorry, there's a little bit of microphone feedback. It's a little bit.
Yeah, can I ask those who are on this call to please put your devices on mute if you are not speaking? Thank you. Go ahead, Dr. Stoltz.
Sorry about that. But yeah, really focusing on the potential interaction of these interception powers with cabinet decision making and sensitive cabinet information, and essentially to outline that, given the importance of proper cabinet process and the significance of cabinet government to the national interest, that my suggestion is that as the bill is drafted, some better attention needs to be paid in the proportionality assessment when these warrants are authorised, if they are ever to be used against a member of cabinet. Noting that, of course, under the current legislation, a judge or AAT member will be assessing whether they authorise the warrant, essentially on its basis of being whether it's a serious crime or not. Typically, an offence that attracts 3 or 7 years maximum or maximum penalty. And I guess I'm arguing that there needs to be, in that proportionality test, a recognition that if this interception is taking place in relation to a cabinet member, particularly a member of the National Security Committee or cabinet, that the potential chilling effect that this interception could have needs to be part of that proportionality assessment. So that's kind of a very broad summation of it. There's some other aspects that we could perhaps go into, but I'll turn over to you and your colleagues for your questions.
Thank you very much, Dr. Stoltz. In your submission, you advise caution in relation to a judge or a high sort of AAT member making judgments about cabinet norms and practices. Why is that?
Well, I suppose it's to say that there needs to be. I mean, I know that the Law Council, for example, has suggested that a Superior Court judge should be responsible for authorising these sorts of warrants generally. I would tend to lean on something resembling that when it comes to a member of cabinet, just because of, as I say, the fact that all these norms and ideas around the proper functioning of cabinet, they're not going to be defined in statute. So a judge or an AAT member can look at a serious crime and say, yes, what you're asking to investigate does constitute a serious crime based on the legislation, and I might approve the investigation on that basis. But there's nothing compelling them to assess that kind of more nebulous concept of the proper functioning of cabinet government. And I suppose this is where the NAC is straying into a space, and is meant to stray into a space that's quite distinct and different from traditional criminal investigations, because we obviously have the federal police and other law enforcement agencies that can investigate serious offences. But the basis for having a NAC is that there is something distinct and something quite special about offences that are also themselves serious corruption or serious corrupt conduct. And I guess I'm saying that as a result of that, the proportionality assessment needs to be done either by different entities, so perhaps a Superior Court judge or some other entity, or at least that it be laid down either in statute or in processes and procedures, regulations, that the judge or AAT member do have some kind of due regard for the potential of the interception to cause a chilling effect on the proper functioning of cabinet.
So, the availability of telecommunications warrants and authorities engaged by the amendment proposed here that we're looking at in this sort of, as you pointed out, very narrow focus of this inquiry would only apply when the NAC investigation is into that kind of serious offence, which would attract a prison sentence of at least 3 years. So bearing that in mind, do you think that the prospect being strong enough to have that chilling effect on cabinet deliberations?
Yeah, I suppose this is where we need to keep in mind the methodology used for investigation. So in this sense, if, for example, a member of staff of a member of cabinet, or potentially even, let's say, a public servant who's a member of the National Security Committee of Cabinet, if a member of staff who might be separated from the decision-making were subject to the investigation, there would still be a degree of incidental collection that poses a pretty high risk of collecting sensitive cabinet information and then creating another repository of that cabinet information outside of the existing system. So while I think it's very fair to say that, yeah, in all likelihood, God willing, you'll never see a member of cabinet themselves commit a serious offence that would warrant the use of these powers. But the reality of incidental collection and the way targeting works is that it's not just those individuals that are relevant here. It is kind of the larger network of people around them as well.
What kind of offences would sit within the serious corruption offence that you propose?
Yeah, that's a really good question, and I was thinking, had I had more time, I would have liked to have kind of done a bit of a Venn diagram where I get all the offences that are relevant as serious offences, and then all the types of corruption and overlay them, I suppose. But I guess it is one does need to kind of use one's imagination to think about the sort of activities. But I suppose fairly serious misuse of government funds. Whether it be relating to, a minister's discretionary powers in terms of grants and those sorts of things could potentially constitute an offence like that. But I think this is also where I'm kind of on the same page with the Law Council as well, that the definition of corrupt conduct that's being used here is potentially a little bit fluffy. And that we might need to actually define more specifically what exactly is the conduct that we are concerned about here, that again takes it outside of the realm of a typical criminal investigation that could be undertaken by the AFP or another entity.
Thanks, Dr. Stoltz. Is the Deputy Chair, are you there? No. Senator Patterson?
Thank you, Chair. Dr. Stoltz, thank you very much for your submission. I think your point about cabinet is well made, particularly because, as you note, the conventions and processes of cabinet are not well defined. And one practical example I want to highlight that's relevant in this context is that, not all deliberations of cabinet actually take place in the cabinet room around the table. in the lead up to a cabinet decision, it's very common for cabinet ministers to try and lobby their colleagues to persuade them of the merits of a proposal they're bringing to it, for their staff to be involved in that process and the staff of other offices. And for those communications to potentially be captured by a corruption commission, I think does have serious implications for the process, for the functioning of cabinet. And that's why, at the very least, I'd like to see the issuing authority be raised to a Supreme Court, to a Superior Court judge. Although I wouldn't limit it just to cabinet, I think the deliberations of Parliament are equally worthy of protecting. Do you disagree with more broadly protecting parliamentarians?
No, I don't, and I note that the Privileges Committee has made a submission seeking to have some greater clarification around how these amendments would interact with parliamentary privilege, and I think that's the point: is that if you observe that parliamentarians and parliamentary privilege warrants some special attention with regards to these powers, and then others have also argued that journalists as well warrant some special attention. I think if we're saying we need to have carve-outs for particular types of Commonwealth officials and other people that are going to interact with the NAC investigation, I would say that therefore you should also be saying that those interacting with cabinet decisions are also worthy of attention, just because of the pertinence of those decisions to the national interest, really warrant, again, some special attention. And I think something I would also encourage, I suppose, is that this committee and your counterpart committee, the joint committee into the NAC, be very well assured that the NAC is going to be appropriately resourced to exercise these powers. Because it is one thing to change the legislation in order to empower them to do it. It's entirely another to make sure that they get the specialist staff, they have the specialist facilities in order to handle this sensitive information, particularly if that sensitive information is going to include information regarding cabinet decision making. So I would hope that there's an ongoing process where this committee and other committees are assured that the resourcing is there to support these powers.
Yes, that's a very good point, and this is one of my principal concerns. This may be one of the last opportunities for the Parliament to express a view about these issues, because quite appropriately, the Corruption Commission and the Commissioner are going to be independent of government and of Parliament. There will be an oversight committee, but the opportunity to influence the legislation which establishes for the NAC is our last best opportunity to put these protections in place. And the evidence from the Attorney General's Department before, when it comes to a whole range of these matters, is essentially that we believe and we expect that the Commissioner will do certain things, not that they will be required to do so by law. So I'm interested in kind of any belt and braces requirements that we could put in the text of the legislation itself to assure ourselves about these protections. One obvious issue is the issuing authority, which we've already discussed, but there are other things, for example, the way in which they protect potentially classified or sensitive information. Are you satisfied on the face of it, of the legislation, that there are adequate requirements that classified and sensitive information be protected?
Well, I suppose I discussed this in my submission to the other committee. I note that there are requirements in place for the notification of the IGIS, for example, when the NAC is investigating members of the national intelligence community. I'm not confident that there is enough laid down in the legislation itself to mandate how the NAC is going to handle collected classified information. But whether that needs to be laid down in the legislation is perhaps debatable. Whether that's something that needs to be arranged in subsequent regulations or other agreements between agencies, you could potentially deal with it there. But I suppose that is, again, another example of something that this committee needs to kind of have ongoing assurance of, that the NAC is meeting all the existing rules and procedures around the proper storage of information. I know that the Attorney General's Department, they laid down very clearly what the protective security requirements are, but the question does have to be asked: if we kind of fast forward a couple of years from now and the NAC has struggled to recruit the right people, has struggled to build the right classified systems, and isn't able to store this information at the right level, I mean, what will the Parliament do then?
And let's just dwell on that for a moment. I mean, the consequences of that potentially could be catastrophic if a foreign intelligence service was able to compromise the NAC in some way, either by getting access to the sensitive information it will store through cyber means or by insider threat or other means. I mean, it is extremely important that these have the most robust protections in place, isn't it?
It is, because essentially any collection, direct or incidental, on Cabinet members will be creating an additional repository of Cabinet information outside of the existing system. We then get into some kind of iffy hypotheticals around, well, is the NAC therefore obliged to notify every relevant agency that they now hold duplicate copies of that top secret information? But how does that work in terms of maintaining the confidentiality of the investigation itself, and these sorts of issues? And again, maybe that's something to be addressed in procedures. But while it might seem, something of a stretch of imagination to say, oh, well, will this information ever actually be collected and therefore will it be targeted? I suppose we have to kind of deal with the worst case scenarios. And again, going back to the proportionality of whether we want to enable the collection of that information and the creation of that additional repository, that target for a foreign intelligence service, if we want to allow that to be created without proper assessment of the proportionality when these warrants are authorised.
And just to be clear, a foreign intelligence service wouldn't only be interested in classified material or material related to the operation of Cabinet. They might also just be interested in salacious material or controversy involving members of Parliament, because that would give them an opportunity to blackmail or extort or use leverage over someone to compromise them, wouldn't it?
Yeah, that's correct. And again, we might be drifting somewhat out of the specific warrants, but that's obviously a concern for any investigation, any law enforcement investigation that concerns a parliamentarian or their staff, is that you might be creating a repository of information, that, as you say, that could be exploited. And a foreign intelligence service is going to be interested in not only the individual parliamentarian but that network, because they're going to want to understand the human network that surrounds that individual to potentially put pressure on them or to create opportunities to exploit them. So yeah, there's a wider methodology at play there rather than just solely the stealing of secrets, which is many of these agencies are up to.
And just to use a kind of recent example with a state anti-corruption commission, the existing corruption commissions we have haven't always been perfect at handling sensitive information. The New South Wales ICAC accidentally uploaded to their website material during the Gladys Berejiklian inquiry that was never supposed to be public. Now, that's the most experienced, most well-established corruption commission in the country. If 20 years after their establishment, they are accidentally uploading sensitive material, I mean, imagine the consequences of a brand new federal commission not handling this sensitive information carefully.
Yeah, and I suppose this is my point is that while there are, of course, other existing corruption commissions that have got a track record of trial and error to refine their processes, there is still something special and unique about the Commonwealth level, and particularly about the decisions that are made by the Commonwealth Cabinet in relation to the national interest and national security, that do set it apart from these other commissions, and therefore do warrant some special scrutiny of exactly how these powers are going to interact at the Commonwealth level.
Yes, and speaking for myself, I don't want to see the NAC use a trial and error process to determine how they handle classified or sensitive information. Yeah. That would not be adequate. Chair, that's my only questions for Dr. Stoltz, but I forgot to put on the record before some questions on notice to the Attorney General's Department. As Mr. Dreyfus did when he was a member of this committee, I wonder if the Attorney General's Department could come back on notice in relation to the specific recommendations made by the Law Council and whether there would be any adverse consequences for the committee recommending any of those recommendations.
Thank you, Senator Patterson. Are there any other members? Ms. Andrews, do you have questions? No.
Hello, apologies. I'm not having a lot of luck with tech. I'm fine. Thank you very much.
Thanks, Ms. Andrews. Any other members?
Thanks, Chair.
Thank you. All right. Well, thank you very much, Dr. Stoltz, for appearing today. Really appreciate it. If you have been asked to provide any additional information, the Secretariat will be in touch, brief timeframes for providing that to the committee. You will be sent a copy of this transcript of your evidence, and we'll have an opportunity to request corrections to transcription errors. Thank you very much for your attendance today.
Thank you. Thanks for your time.
Thank you. Colleagues, there being no further witnesses, I declare this public hearing closed and look forward to seeing you all on Monday. Our next meeting is Monday at 4 o'clock. No, Shenya, correct me if I'm wrong. When's our next meeting? 4 o'clock Monday?
Chair, it's Robert. It's Tuesday.
Tuesday. Thank you, Robert. Tuesday. We'll see you all on Tuesday, colleagues.
Thanks, Chair.
Bye.
Thank you.